Welcome back. Now, the Jubilee administration is on the spot again, this time for new powers given to the president through the JSC Act that was amended to give the president powers to recruit top judges and police officers. Now, LSK, that is the Law Society of Kenya, is expected to move to court today to file a case challenging this move. It has engaged 4 lawyers, that is Namba Gitonga, Tom Ojenda, Michael Moshemi, and Peter Wanyama, to pursue the case. LSK's contention is that the amendments to the JSC Act contravene the Constitution by essentially giving the president powers to appoint the Chief Justice and his or her deputy. Now, on Power Breakfast this morning, Muteki Njau is joined by the LSK chairman, Eric Mutua, to put perspective on this matter and to paint the picture really of where we are and where we come from and where we are going should this amendment be allowed to go on. And our SMS number is 22422. If you want to send in your questions, your views, and your comments on the same, that number again 22422. And on Twitter, of course, you can keep talking to us. The hashtag to use, as always, is Power Breakfast. We'll take it.
Good morning and Happy New Year.
Happy New Year. Good morning.
Mr. Mutua,
yes.
What is the act as it is now, and what is offensive?
The act as it is, the Judicial
Public, for the public good, you know.
The Judicial Service Commission Act as it is now is basically extracted from the Constitution. Specifically Article 166 in terms of the appointment of the Chief Justice and the Deputy Chief Justice and other judges, and it provides specific that when it comes to the appointment of the Chief Justice and the Deputy Chief Justice and the judges, it is a body known as the Judicial Service Commission, which is given the constitutional mandate to determine who is the most suitable candidate or person for the office of the Chief Justice and the Deputy Chief Justice and of a judge. And it provides further that once the Judicial Service Commission has determined the person who is suitable for appointment as a Chief Justice and a Deputy Chief Justice, what it does is to recommend to the President and tell the President, we recommend that so and so ought to be appointed. And though the President does it ceremoniously, he now appoints that person and forwards that name to Parliament for purposes of vetting. That is what the Act provides as at now. Not as at now, I mean the old Judicial Service Commission before the amendment. Now, the amendments which have been introduced by Parliament, they were introduced on 1st of December on the floor of the House, and I'll come back to that, provide that instead of the Judicial Service Commission recommending to the President the person who is to be appointed as the Chief Justice and the Deputy Chief Justice, it now dictates to the Judicial Service Commission and tells the Judicial Service Commission that when you do your recommendation, you need to recommend 3 names, not 1. It therefore negates what the Constitution provides in terms of it now gives conditions to the Judicial Service Commission, which is the body charged with the responsibility of recommending. Now it tells them, recommend in this manner. And therefore, that is what offends the Constitution in our view as the Law Society of Kenya.
And the justification is that you want the President to have 3 names, not 1.
Yes.
I think they were finding it difficult to get 1 person.
No, they were not finding it difficult. The Judicial Service Commission has never had a problem in finding 1 person. Once it conducts its interviews, it will basically pick the most suited person and recommend that person. The danger is that once you pick, when you are told to pick 3 names, first and foremost, now you have amended the Constitution by telling the body that is charged with that responsibility that this is the manner in which you do the recommendation. That is first. Secondly, when the President proceeds to appoint 1 out of the 3, he is now given a discretion. If, for instance, the Judicial Service Commission were to find in terms of ranking that number 1 is X, number 2 is B, number 3 is C, in terms of ranking,
the President
can pick C. The third one, because there's a discretion now which has been bestowed upon the president. He can pick C without any explanation, because the law now has been amended to the effect that he's been given that discretion, and he doesn't have to give any reason why he has opted to pick number 3 and not number 2. That is where now politics comes in, and that is our problem, is that what is going to happen is that the persons who are interested in controlling the judiciary, in controlling the office of the Chief Justice, what they will need to do is to undertake some kind of manipulation at the body, that is the Judicial Service Commission, because we have some of the commissioners, and we know that some of the commissioners are sympathetic to the Jubilee government. So what is going to happen is this: they are going to manipulate and pick among the 3 one person whom it is already decided that is going to be the Chief Justice. And therefore, when it comes to the president nominating one of those 3, they will go for the person whom, from the word go, they had identified and put them through the process.
In the current situation,
yes,
when the Judicial Service Commission identifies a person, like the current Chief Justice,
yes,
and then is taken to Parliament for vetting,
yes,
what would happen if the Parliament disapproves?
In the current situation, after the amendment now, what is
before the amendment?
What's the law? Before the amendment, they have to go back to the Judicial Service Commission and ask for another name.
Another name.
Yes, but at the current situation is that if Parliament decides that the name which has been picked by the President is not suitable for one reason or another, then the law as it is now provides that they would ask the President to pick another one among the 3. Then the President will pick another one among the 3. If the second one is also declared unsuitable by the Parliament, the President will be required to pick the other one. And then they would now go back to, if the same situation prevails, they will go back to the Judicial Service Commission to provide another set of 3 names for purposes of nomination. That is the current situation.
So your main contention is that the President will have a discretion. And
yes.
But the Judicial Service Commission is the same one. When we say they will manipulate, with somebody, some Judicial Commission members may be sympathetic to Jubilee and therefore may nominate a certain person who is...
Yes.
Why can't they nominate, instead of nominating 3, nominate the one they want?
Because now they have been told by Parliament through that amendment that you cannot now give us one name, give us 3. It is now a law that instead of giving the one name, if they were to give one name, they will have violated the amendment. So they must keep with the provisions of Section 30, which has been amended, to the effect that they've now to forward 3 names instead of 1.
You say the original amendment did not include that.
Yes. If you look at the Statute Law Miscellaneous Amendment Act 2015, the bill itself, when it was published on 18th of September 2015, the amendment to the Judicial Service Commission Act only provided the timetable as to when is the name to be forwarded to the President, what time is the President going to forward them, the timelines. It only talked about the timelines. But what happened is that on 1st of December, when the bill was under deliberation in the floor of the whole House, the chair of the Justice and Legal Affairs Committee, Honorable Chepkonga, he introduced an amendment to the said Miscellaneous Amendment Act 2015, or Bill 2015, and proposed that, and that is in the hazard. If you look at the hazard, it will tell you that. And he proposed that instead of having just names, we should add the word 3. So it is now provided that the President forward 3 names. Interestingly, when you look at the hazard, when the Speaker, the Deputy Speaker who was chairing, asked whether there is anyone who has an issue with those amendments, apparently the entire of the House went quiet. They did not protest. That is what happened. But when I went through the hazard clearly, I noticed that the chair, towards the conclusion, when the bill was being passed, towards the conclusion, you will see Honorable Kajwang, who was the speaker then, the deputy speaker, who was chairing. You will see what he says. He tells the minority and the majority leader to go and confirm whether they have a quorum for purposes of the vote. Then they came back to him and told him that they have a quorum. He was not very sure. Again, he told them, no, I doubt what you have said. Could you please go back and confirm with the Sergeant at Arms and the clerk? Physically consult with them and find out whether exactly we have a quorum. That tells you that there was a problem from the word go of a quorum. Now,
this amendment.
Yes.
The offensive thing is mainly about the way it was done.
First and foremost, in terms of procedure.
Yes.
If you publish a bill, it is expected that any person, in terms of the members of the public, who has an issue with what you have published as a bill, it will go through public participation. People will make recommendations and make comments and say this is not acceptable, this is acceptable, or because of reason X, Y, Z, we cannot allow this kind of law to be passed. And the publication, as it was done on the 18th of September, it did not have that provision for 3. Therefore, we, among the stakeholders of the Law Society of Kenya, we never saw anything wrong with those amendments, because it is a question of
timing,
providing timelines within which those names have to be taken to Parliament. But when you introduce that amendment in the floor, which is very substantive, to say that now we want the Judicial Service Commission to provide 3 names instead of 1, what you have done is that at that point in time, because that is the same day it was passed, you have nobody else to comment other than the members of Parliament in the House. But the public, the stakeholders, you have not given them an opportunity to comment. And that is exactly what happened when this bill was passed. That is one. Secondly, as I've said, it is clear that if the Constitution provides that the body that is charged with the responsibility to recommend the most suitable person for the office of a Chief Justice and Deputy Chief Justice is the Judicial Service Commission, you cannot use a statute, an act of Parliament, to now dictate to that body the manner in which the recommendation is going to be made. Once you do that, you automatically violate that Article 166, and that, in our view, is a violation of the Constitution, and the courts will have no problem in declaring that section as a null and void. And again, the urgency of this is that we know the question of the term of office for the Deputy Chief Justice may be decided probably next week. And remember, the Judicial Service Commission has already started the process of recruiting the Deputy Chief Justice. If this law is allowed to remain in place, what happens is that now the design by the persons who are interested to manipulate and control those offices, they will now be able to get their way in having 3 names forwarded to the President.
What is the justification for Chipukonga to give the 3 names and not 1?
Well, for me, I'm presuming this is a scheme. This is a scheme where it is easy to get
Chief Justice of the like.
Yes, a person who is probably likely to get keep at the judiciary for the executive when you have 3 names. But it's very difficult when we are dealing with just 1 recommendation, because the entire Judicial Service Commission will have to sit and vote for the best candidate.
There is also the appointment of the Inspector General of Police and the deputies. It was also in that one of those things.
Yes.
Why are you raising about the Chief Justice and not the police?
Well,
why are you not raising issues about that?
We have not said it in public, but we have a discussion with the Kenya Human Rights Commission over that issue. I've had a discussion with FIDA over that issue, and FIDA and Kenyan Human Rights Commission are likely to file a suit in respect of the question of the discretion, the powers which have been donated to the President now to fire the Deputy Inspector General of Police, the 2 deputies, and the Director of CID. Why? Because when you look at the historical context in the constitution making process, and when you look at the views that were collected by the commission during the constitution review making process, and when you look at what was said in Bomas 1 and 2, there was an issue which was running across as a thread, and this was the reforms to the police and the independence of those offices. And if you ask me my interpretation, although the constitution does not indicate the manner in which the Deputy Inspector General is to be fired, if you look at the manner in which the dismissal of the Inspector General is to be done, for me, and take into consideration what Kenyans wanted when they voted for this constitution, is to give some autonomy to those 3 offices, the Inspector General and the 2 deputies, and that is why they were provided for specifically in the constitution, such that there will be no political manipulation from the president or from another politician, especially when it comes to issues relating to transition after an election. So that's taken into consideration. It means, therefore, in our view, that amendment where the president now has powers to dismiss or to retire the 2 deputies and the Director of CID is also unconstitutional, because when you go to the interpretation of the constitution, we must look at both the letter and the spirit of the constitution.
The argument is that the president is hamstrung. He cannot control security. He cannot manage the security. You say the president, you blame the president for insecurity.
Yes.
In that he cannot appoint or move this.
These are institutions. The president.
That is what the argument is.
I think that argument cannot hold water, because the president does not maintain security, as it were, strictly speaking. There are institutions and there are persons who are given the mandate to do that. And all he needs to do, if one fails in that mandate, if one does not execute that mandate in terms of security very well, there's a mechanism to check that person. There's a mechanism to remove that person. And we need to follow that mechanism. If you put in terms of scales, the question of following the mechanism and having someone given the powers to do what they want to do with the police, then will always the issue of due process will carry the day. Because once we give them independence and there's a mechanism to remove them if they violate the law or if they don't maintain security, then we should follow that mechanism, including the president. Remember, the constitution is supreme.
Is the Inspector General independent? As we speak now, we are the way the constitution is provided, and the way the appointment of the initial appointment of the Inspector General, there is an independence. And if you interpret the constitution strictly speaking, there is independence of the Inspector General. However, because there has been amendments to the National Police Service Act and other security laws, some independence has been removed from the Inspector General. And is that right?
It's not right, of course, it's not right. But that has happened. You see, as I said, if you even look at the security laws which were passed, the first thing is, in a statute law miscellaneous amendment bill, it is supposed to just help the government to rectify minor omissions, inconsistencies, and old terminologies, removing the old terminology. For instance, if the old penal code or criminal procedure code provided for Attorney General, and now under the Constitution we have the Director of Public Prosecutions, all it needs to do is to use the miscellaneous amendment bill to remove the word Attorney General and replace with Director of Public Prosecution. Just minor amendments. But when you introduce substantive law through those amendments, then first and foremost you violate the principles of public participation. That is exactly what happened with the security laws in 2014, last year but one. You remember, until it was challenged in court because they were introduced through miscellaneous amendments. Therefore, when you look at even from 2013, 2014, 2015, there's a systematic and calculated way of trying to amend, in quotes, the Constitution through statute. Because it is very difficult to amend the Constitution currently, what I think the advisors of a government have done, or misadvised the government, is to tell the government that the only way to deal with these situations, difficult situations, is through Parliament by enacting law which is contrary to the Constitution. And that is why I keep on saying that you only need to look at the cases which are being filed in court to challenge the laws that have been made in Parliament. I can tell you 4 out of 5 statutes which have been passed by Parliament have been challenged in court. And out of those, 3 have had certain provisions declared as null and void, because there has been a very persistent attempt to amend this Constitution through statutes or through acts of Parliament, which is a very dangerous thing, because we are basically slowly gravitating towards an autocratic presidency or government, imperial presidency, or with powers, with all the powers, and we are basically weakening institutions and independent offices.
There is a hue and cry, particularly I think from lawyers, and one of you, I think, was you and Moite, about the expiry of the CIC.
Yes.
And they did not get an extension, and therefore the implementation of the Constitution will be done by the Law Reform Commission.
Yes, what we said is that as much as the CIC cannot be said to have performed extremely well in its mandate, but the role that it played, being an independent constitutional office or commission, is very critical, especially in checking and confirming that all the bills that were intended for purposes of implementing the constitutions were constitutional in nature and did not violate the Constitution. Our concern is that when CIC exists and we don't have that kind of independent body, and we give this mandate to the Kenya Law Reform Commission, which is a department under the Attorney General, first and foremost, what you lose is the independence itself. They would only act probably upon directions by Attorney General. They may not contradict the Attorney General. And if, for instance, this miscellaneous amendment bill, with all these issues, including the Auditor General, including the issue of the police, including the issue of the Chief Justice, all this, the miscellaneous bill, first and foremost, is generated from the Attorney General's office. Ministries and other government agencies would look at the law that they are following, and if there are difficulties in operationalizing that law because of inconsistencies with other laws or because of some omissions, they will notify the Attorney General. Then the Attorney General would now draft a miscellaneous bill. If it is this office of Attorney General which has done this mischief so far, then what guarantee do we have as Kenyans that a department under him called the Law Reform Commission is likely to check and speak to bills which are unconstitutional, the ones which are in Parliament, for implementing the Constitution? But you have already
told me that since 2014,
yes,
those amendments, those miscellaneous amendments have gone through and they have been challenged in court. Why was that happening and CIC was there?
Well, that is why I said in my opening statement, I said, although they have not done as expected, at least we have seen them speak to issues, we have seen them criticize, we have seen them go to court to challenge some of the bills which are being tabled in Parliament, and some of the acts. We have seen them work. They have spoken. They did not have police powers. Let me use that word. They did not have police powers where once the parliament has enacted bad law, they would arrest the situation immediately. The option is to go to court and educate the public and advise the president and the parliament on some of these laws. So their powers were limited to, after they have said whatever they have said and it has been ignored, they go to court. So still some of these laws were being passed, but some of them, CIC was against those kind of laws.
Now that the term of office is over, and what are you offering?
Well, for us,
what would you suggest?
For us, what we were suggesting is that at least they ought to have been given an extension for 12 months. It is very critical, so that at least we can get through the pending bills and the pending laws that were to be enacted in implementing the Constitution. That is one. But as the Law Society of Kenya, we knew that probably we may find ourselves in this kind of a situation. If you remember last year in November, we constituted a committee headed by Dr. Kamau Kuria and Professor Piolo Lumumba, which was a committee for purposes of ensuring that there is proper implementation of the Constitution and the rule of law is adhered to. And that committee, in our view, is going to step in and look at all the bills which are coming from, which are tabled in Parliament or which are published for purposes of confirming whether or not they are in conformity with the Constitution.
Where the reason why there's a lot of issues about this is retirement of one Chief Justice.
Yes, yes.
And as you say, the Deputy Chief Justice case is still pending. Are you kind of seem to imagine that they are not, the new process will not sustain the separation of powers?
Yes. We are even more worried that these amendments have been introduced when we are in the process of recruiting the Deputy Chief Justice, and when we know by June we'll be recruiting a Chief Justice. The timing is so wrong, and anybody can read mischief in the timing. Remember, by June, if all goes well, by June we are going to have a new Chief Justice and a new Deputy Chief Justice, which judges or judicial officers sit at the Supreme Court. And the Supreme Court is the one which is given the constitutional mandate to determine a dispute arising out of a presidential election. Therefore, as we sit, we think that the stakes are so high, and that is why these amendments have been introduced to the Judicial Service Commission Act.
What would happen if you lose the case?
I don't think we'll lose the case, but in the event we lose the case at the High Court, we are going to appeal to the Court of Appeal. If we lose at the Court of Appeal, we are going to appeal to the Supreme Court.
There is also, I saw some other amendment that is removing power from the Communication Authority.
Yes, this is as I say,
the same miscellaneous.
The same miscellaneous. It has interfered with powers in the Communication Authority, because people must control the media. It has also, and this is very critical, it has also interfered with the powers of the Auditor General. If you interfere with the powers of the person who is supposed to audit you, remember the Auditor General is the one to audit government expenditure. And if you have told the Auditor General that in terms of his funding, he has to go and borrow, and if there is no funds, you cannot undertake your work. In terms of recruiting, he has to get recruitment undertaken by another body, not himself. Chances are that you would weaken that institution. And that is basically what has happened in terms of those amendments. The Auditor General is not going to be independent, and once you remove that independence, then you are able to be able to twist the Auditor General in terms of what is going to audit.
In fact, this is a repeat of it. You remember during my time, there was a time they created a different Auditor General for parastatus.
Yes.
Because the other one was very powerful. So we are going back to Moise.
And I've read somewhere, it's very clear. The only difference between what happened in 1963 when we got the independent constitution, which was a very good constitution, then it was amended piecemeal by Parliament, up until 1969, when we had to publish a new constitution, another constitution with all those amendments. Because what was original with the good constitution in 1963 through amendments was watered down. The only difference between that and what is happening after we promulgated this constitution is that then there were amendments which were being directed to the constitution, and the numbers, it was easy to amend the constitution in parliament, and that was done. Now, because it's difficult to amend the constitution, what has happened is that they have devised a way of dealing with those amendments through statutes. Anything passed in parliament will interfere with what is in the constitution, either in the constitution or to look for mechanism to go around those kind of provisions. That is the only difference. Otherwise, both 1963 to 1969 and 2010 to 2016, which is exactly 6 years. Each is 6 years. That is what has happened. The only difference is that there were amendments to the constitutions, and these are amendments to, these are done by way of statutes.
There is some wrangling going on with the Law Society of Kenya.
Yes.
Do you think it is also involved? It's involved. Is that?
Well, I've said it before. Yes. These issues you saw last year about the development of the project we were undertaking, yes, the arbitration center. There was nothing to do with the arbitration center. Have you heard anything about arbitration center? Now we are going to election, because what had happened is that they knew that it is only the Law Society which can raise some of these issues, and they had to look for a way to try and stifle the voice of the Law Society. That has not succeeded. What they have done now, they have candidates for both the position of the president of the Law Society and candidates for the position of the deputy president of the Law Society. They want to see whether they can use that question of the arbitration center to manipulate and get their own persons to lead the Law Society, which I can tell you is not going to happen. Lawyers are very sharp. Lawyers are very good when it comes to voting, and I don't think that they will succeed. Any government candidate, any project by the government to run the Law Society will always fail. That happened to me in the first election and the second election, but I succeeded. Thank you.
The arbitration center?
Yes.
Why are you saying that there is no issue?
It was not an issue. The arbitration people are still paying, and the issue of what to construct and how to do it is still ongoing. And there's no one who is now raising and saying, oh, we have the arbitration center issue. People are still paying through the fees that we charged, and it has gone quiet. Have you heard anybody either in social media or either in the mainstream media talk about it? Because we are now going to an election.
When is the election?
The elections are on 25th of February. And there are candidates who are pro-Jubilee, and we know those candidates.
And there are candidates who are pro...
there are no candidates for... The only candidates who are geared towards the rule of law and the independence of the Law Society.
There are no court candidates?
There are no... I've not heard anybody accused of being a court candidate.
How do you know they are the Jubilee candidates?
Because you look at what they have been posting. There are people who have been who have websites campaigning for the Jubilee from 2010 all the way, and now they are candidates for the Law Society. If you look at what they have been posting and supporting the government, whether the government is wrong or right, they have been persistent with that agenda. Now they are saying they are running for office. That person, you can always make a conclusion that is a candidate who is placed in that position for purposes of coming into council and to control the Law Society.
Well, do you think the Law Society should always oppose the government?
No, the Law Society supports the government. Remember, there are instances personally where I've said the president has done very well on this account. But because when it comes to violation of rights of citizens and institutions, it is always the government which is culprit. And because we always say so, we always say this is wrong, we are viewed as being an opposition to the government. Remember, at times we say the judiciary has acted wrongly, it has misconducted itself. So remember when I talked about the Supreme Court judges, and I criticized them because of what they did. I still believe what they did was wrong. But when now the institution is under attack, I'll have to come out and say, wait a minute, as much as they have done this, but as an institution, if we don't protect the judiciary, then we are likely to end up in a situation where after an election, God forbid, if there is a dispute which is violent in nature, then after that, people will not want to file any cases in the courts, and they may want to settle their scores outside the court. And that is what we should be guarding against.
Thank you very much.
Thank you. Thank you.
Well, Kenyans, you have heard yourself that we probably are going backwards.